that you don't get to exercise the privilege. The president does. You would argue here by extension the former president does.
안녕하세요. 매일매일 운동을 하고 있는 동타왕토입니다. 지금 계속 여기 목 주변이랑 아파서 제가 한의원을 다니고 있는데 내일 또 한의원을 가는 날입니다. 일단 스트레칭 위주로 매일매일 하고 있고요. 네, 팔굽혀펴기도 하고 있고요. 오늘은 출근인데 오후 출근입니다. 네, 왜 이렇게 피곤하지? 잠 많이 자는데. 아주 햇살이 아주 좋습니다. 근데 밖에는 아주 춥죠. 다들 감기 조심하시고요. 오늘도 운동을 하도록 하겠습니다. 역시 운동할 땐 CNN이죠.
The bereft of any analogies as to how to handle privilege claims. I mean, lawyers deal with this, as you well know, and Ellie knows well. I would, at least in part, to attorney-client privilege. I mean, you know, I understand the position in the political environment that truth is an absolute and that the committee is entitled to get after the truth. But, you know, we have privileges that also stand in the public interest to protect certain things. One would be attorney-client communications, notwithstanding that they may actually reveal what the truth is.
But that privilege, Robert, runs with the client until they die. That is not an analog to what happens with a president. It runs with the office, not the office holder.
But the executive branch has a claim here. Whether Joe Biden has chosen to assert it, you know, Donald Trump, as the Nixon versus Administrator Court also recognized, the former president does have the ability to assert the privilege. Now, whether it's enforceable or not, you know, I think is probably a facts and circumstances question. But here, the former president has invoked, which is going to be relied upon by both Bannon in a prosecution and presumably by Mark Meadows as well in contention with, you know, how he deals with Congress in the future.
But how has Trump invoked the privilege to stop Bannon and or Meadows or anyone else from testifying, Ellie?
He sent a letter saying, yes, I would like you to I would like you to give me a chance to play this out in the courts and see how it comes out. Now, Bob's right that privileges are important. We shouldn't just throw all privileges out the window because we want to know everything. However, and that's exactly why Steve Bannon is in a tricky spot here. Steve Bannon would have been much better situated to defend himself if he was selective, if he said, I invoke privilege as to my specific subset of communications, perhaps communications that Donald Trump had with me about legitimate policy issues.
But isn't that something Trump would have to do? How does Bannon invoke any privilege? He doesn't have one. It would be him as an instrument of Trump's communications.
Exactly. He's trying to back in on Trump's very broad invocation. So what I said applies to both Trump and Bannon. If they were selective and said, I want to invoke the privilege only as to this narrow set of protected communications, they'd be in a much better situation. Instead, remember, Chris, April 2019, Donald Trump walks out onto the White House lawn and declares, we're fighting all the subpoenas. And if we thought he was kidding, no, he meant that literally. And he has invoked executive privilege so broadly that he's hurting himself, he's hurting the people around him, and he's undermining the privilege itself.
How do you think it winds up, Robert?
Well, you know, the preferred way is what as Ellie suggests, that you would invoke selectively once appearing to say, well, I can answer this question, but I can't answer this question because I think that it raises information that I think is protected by a privilege that the former president has asserted. That is the preferred course. I mean, the problem in this area is it would be helpful if a court would actually sort out this stuff first, and then you could have testimony. The committee hasn't been willing to wait for that. And, you know, they've now brought a prosecution by the Department of Justice while you've got litigation pending before the D.C. Circuit that raises at least...
it's a righteous claim. I mean, that's why, Robert, that you've never had a former president exercise it. You've only had it exercised through the current president by suggestion. The fact on your side is, well, if you don't protect communications between the president when he's sitting and his staff, if you can always just unpack it afterwards, is that what was intended? And we'll see what the appellate court says on that.
Yeah, they may be right or wrong about that, but it's I mean, I think it's a pretty dangerous position to be in terms of bringing a prosecution while you've got litigation outstanding that hasn't yet been resolved, that at least raises, I think, what was probably going to be deemed a core issue here. And again, the Justice Department may think that has no merit, but nevertheless, there's still litigation pending.
Well, we'll see what happens at the appellate court level. I have to tell you, especially on a Friday night, this is a real gift to the audience. Robert Ray, you made your position very explainable. Ellie Honig, cogent as always. Really appreciate it, guys. Thank you very much.
Thanks very much.
All right. the Kyle Rittenhouse
Bob.
trial, getting more complicated. Closing arguments are coming. Why? Well, the jury could decide charges that weren't even offered up until now. Why would the prosecution want more charges now? And what would they be? And the judge, is his demeanor an issue? Would it be the basis of a legal challenge? Next.
What's it like being a high-profile Trump supporter
I wanted to try to make him the best candidate he could be.
turned sharp critic?
I felt absolutely sick to my stomach.
Find out when I talk to former Governor Chris Christie about his Jersey roots,
I've been to 137 Springsteen concerts.
his weight,
How could you be a leader? You can't push yourself away from the dinner table.
and the future of his party.
힘들어.
Considering running for president in 2024.
Join Dana Bash for Being Chris Christie, Tuesday on CNN.
The world's biggest business stories in one place. Expert analysis from every corner of the globe. Marketplace Africa, Asia, and Europe. Plus, all new Marketplace Middle East with CNNBusiness.com.
Once in a generation opportunity.
Technology, innovation, business. Tech for staying fit.
From kind of the push of a button, it turns into an interactive home fitness platform.
Tech for athletes.
These sport algorithms are really easy applicable to other sports.
Tech for new realities.
When people go in there and they're in that virtual reality environment, they end up forgetting that they're even working out.
This is Tech for Good.
I'm Christine Bistout. Meet the minds behind the technologies keeping athletes and everyday people in shape.
Tech for Good. Today on CNN. In association with Samsung.
You realize that you have to take people with you, that you're only as good as the people you surround yourself with. But there has to also be a confidence that the leader has in the team and themselves to be able to succeed. Because if you don't have that confidence, you're not going to be able to attract followership. And we have great followership in this company. People love working for this company. The culture of the company is what sets us apart, and it attracts customers.
힘들어.
It's easy to find nutritious, meat-free meals at your local Indian restaurant. Dal is a dish made of lentils, and lentils are filled with protein and fiber. Chana masala, an Indian favorite, made mainly of chickpeas. That means it's full of fiber, iron, folate, and vitamin B. And aloo gobi is a potato cauliflower dish that's flavored with healthy turmeric, ginger, garlic, and cumin. Another cuisine to try, Ethiopian, which is usually full of nutrients and it's low in fat. The meals are usually served on a whole grain flatbread made from the super grain teff, which is high in protein and calcium, and it's gluten-free. You can use that flatbread to scoop up thick vegetable stews. Try a stew made of split peas or ground lentils, or bayanettu. It's a vegetarian sampling of curries, stews, and vegetables, all placed on that healthy flatbread.
A sad sign of the times. Tonight, 500 Wisconsin National Guard troops are on standby outside of Kenosha ahead of a potential verdict in the Kyle Rittenhouse trial next week. We're not even at the closings yet. That'll be on Monday. The judge gave just under 3 hours for each side. It was a very dramatic week of testimony. You don't see a defendant in a case like this on the trial often, but he was there and he offered up an affirmative defense, which means that he had to offer proof of the same. There is a burden in proving the affirmative defense. Obviously, the prosecution has the ultimate burden, but the idea that Rittenhouse doesn't have to prove anything to claim self-defense doesn't make any sense. Okay, I know people are saying that to you out there. They're lying. Now, the judge was also an issue. He had a bad relationship with this prosecutor, at times in the presence of the jury. Now, would that be an issue? Depends. How prejudicial was it? On what issues was it? What did it mean? Earlier today, prosecutors asked that the jury be allowed to consider lesser charges on several of the criminal counts. Why? They're hedging. After going through, this is the privilege of the prosecution, by the way. They have the ability to add or amend charges. But watching them this week, gauging Rittenhouse's effectiveness, they made this call. It shows that they are confident that they were going to get it on the original harsher charges. While the judge will issue a decision tomorrow, let's break down what he is likely to decide, whether he has good grounds to deny that, and what we saw this week. Top legal mind Joey Jackson, and new friend of the show, Elie Mystal, justice correspondent for The Nation, who has followed this case from the start. In deference to our new friend of show, Joey, let's give Elie a crack at this. In terms of your observations, do you believe that lesser charges are going to be allowed, and do you believe this judge's demeanor will be heard about again on appeal by the prosecution?
The judge has been extremely biased towards Rittenhouse from the beginning, not of the trial, but of the entire case. I'm talking about his pretrial motions, his refusal to kind of force Rittenhouse to adhere to his bail release terms, and that is carried through straight through the trial to the point where on the last day of the trial, Rittenhouse's expert witness got a clapping from the jury pool because the judge ordered them to give a cheer for veterans on Veterans Day, and it just so happened that the expert witness was a veteran. So the judge's demeanor has been biased throughout. Does that lead to an appeal? Well, not if there's an acquittal. Quite frankly, we have a system where if you are acquitted of a crime, it becomes very hard for the prosecution to retry you. It's called double jeopardy. It's a great rule. We probably shouldn't we don't want to live in a world where the prosecution gets to try again and again and again to get people until they get it right. But because of double jeopardy, any motion that isn't kind of appealed all the way up to the Wisconsin State Supreme Court in real time, which none of these have been, means that whatever, if Rittenhouse walks on whenever the jury, sometime next week, that's it. That's ball game in terms of this case, this circumstance, this case.
Very fair analysis. However, Joey, the comma is, what if it's hung? And they want to retry, and the prosecution wants to bolster their case. That's where misgivings about this judge's demeanor may come up. But more imminently, do you believe the judge allows the prosecutor to present lesser degrees of the charges or additional charges?
Yeah, well, a couple of things. I mean, you could argue the judge is biased, and I think you have a good argument, as Elie suggested, in that regard. But let's remember, before we get into that, Chris, that he allowed for provocation to be argued by prosecutors. That's huge. What does that mean in English? It means that the jury will be instructed, right? Jurors are given specific instructions as to how to evaluate the facts. If the jury concludes that Rittenhouse provoked the attack, then you lose the privilege of arguing self-defense. And so that is a major boon for prosecutors.
Can you not argue it perfect or imperfect at that point? Can you argue it partially at that point? Or no, not at all in Wisconsin?
No,
it's totally no.
Yes, because what you're saying is you have to exhaust. It becomes a higher burden, really, from a defense perspective, because now you have to say that you've exhausted all and every avenue before you actually engage in the act of self-defense. So this was a big, big win for the prosecution. With respect to lesser included offenses, let's just be clear about what they are. You mentioned it, Chris, that you hedge your bets, right? Because what happens is sometimes you go all or nothing if you're the prosecutor. It's either you convict on the top counts as they are delineated. He was intending to kill, he recklessly killed, he killed with depravity, or nothing. What they said, maybe it's not that. It could be some degree less than that. Maybe it's not a depraved heart, but it could be something else. And that gives the jurors more bites at the apple to convict you. And so that in and of itself, if the judge permits and allows lesser included offenses, it may not get a conviction on the top counts, but it gets a conviction of another count. And that can be detrimental. And that's why we saw, Chris, the judge really allocuting him and saying to him, do you recognize what lesser includeds are? Are you agreeing to that? Do you realize that by agreeing, you can increase your probability of a conviction? But I think that, the last point, Chris, the instruction is given if there's any view of the evidence which would support that charge. And so you weigh the facts, and if there's any view of the evidence, right, that supports the charge, then you give the instruction. So it could be likely that the judge could do just that with respect to other lesser included offenses.
Ellie, last word to you. Here's the question. Do you believe that Rittenhouse, against the prosecution, came out on top in the victim versus vigilante analysis? That's what provocation is about. Whether or not he started this and therefore he can't claim defense, or this was done to him and he had to run for his life and that's why he had to shoot. Which do you think came out more cogently?
Well, I think Rittenhouse did because the judge didn't really let the prosecution put on the case. Like that was the big bias that I saw in this case. The prosecution was trying to make various kinds of provocation arguments throughout, and the judge repeatedly cut them off. So when you say, like, how's the jury going to look at it, it's kind of like saying, well, how do I look if you only photograph me, like, above my first chin? I look thin, right? I could be a thin guy. It's only when you get the full picture that you understand how svelte I am, right? And that's
I'm here for all of it, by the way, Ellie. I'm here for every piece. You look good.
The jury only got what Bruce Schrader, what the judge allowed them to see. And if you only look at what the judge allowed them to see, I think it's a very tough case for the prosecution. And that goes to the sad thing that you mentioned at the start of your program, that that's why there are troops in Wisconsin. It's not because we are a violent nation or ripping, it's because we don't trust the system. We don't trust the process. We see the judge, we hear his ringtones, we see his answers, we see the jury, which is 15-1 in terms of 12 jurors, 4 alternates, 15-1 white people versus 1 person of color. We see all that, and that's why you have troops on the ground in Wisconsin right now.
Ellie Mistal, thank you very much. Joey Jackson, as always, a pleasure. Welcome to the show. Don't beat yourself up like that, Ellie. On hair alone, you win the contest. Right? Joey and I, we're not the worst looking guys, but you beat us because you got a signature look. All right, have a great weekend. I'll see you both again soon. All right, to the other big case with vigilante and racial undertones. The defense attorney at the Ahmaud Arbery murder trial is sort of apologizing for his comments about black pastors. I can't believe I even just said black pastors. You're either a pastor or you're not. This was code. So is an apology enough? Or should he be removed from the case as a rep for the Arbery's, as a rep for the defendant? Arbery's family wants that. Should they get it? Next.
People used to think creativity was out there. Distant, ethereal, only for those with their heads in the clouds. But we know that's not true. Ideas cross our minds every day, and each one is a spark, a force, the beginning of a possibility. And what makes you creative is what you do with it. It's where you take it. It's whether you bring your inspiration to the right place that breaks limitations to ignite it, grow it, nurture it, share it with those who will transform it into a game, a story, a world, a pioneering leap that could light countless sparks for millions more, powering the infinite ecosystem of human creativity for generations. And let's not forget the businesses that drive our ambitions. It's why now more than ever, we need a home, a hub, an incubator for all those who understand, who dare, and who believe in the future of their spark.
The fog lies dormant. The angels fly.
whole idea behind Indigo was to make sure that it was versatile and it could exist in any space. It's a multi-sensory experience when you're in the live show, and it's a multi-sensory experience when you're watching it digitally.
When you cry.
Indigo was basically my construction of a space that was allowing me to reach inwards. My mandate as a composer is to export to the world our capacity to create original content. All right, we've got it.
I'm Blake Essig in Tokyo, and this is CNN.
No holds barred.
Out front tonight, hypocrite in chief.
No nonsense.
How stupid do you think we are?
Facts first.
Senate Democrats, they're getting their butts kicked.
Because getting to the truth matters. Aaron Burnett out front, Tuesday to Saturday on CNN.
When you travel the world, make sure the world travels with you. Check in, log on, and get connected with all of the latest developments at your fingertips. CNN Partner Hotels, connected to your world.
No holds barred.
Out front tonight, hypocrite in chief.
No nonsense.
How stupid do you think we are?
Facts first.
Senate Democrats, they're getting their butts kicked.
Because getting to the truth matters. Aaron Burnett out front, Tuesday to Saturday on CNN.
There's something to be said today for having a news show that's a reliable appointment. What happened today? What does it matter to me? Every day we can guarantee that what's most important is going to be on the menu. That's the mission of Hologram tonight.
This is CNN. More people get their news from CNN than any other news source.
One of the defense attorneys in the Ahmaud Arbery murder trial, you've actually seen him on this show. He tried to do his own PR in court today. Listen.
Very well. I will let the court know that if my statements yesterday were overly broad, I will follow up with a more specific motion on Monday, putting those concerns in the proper context. And my apologies to anyone who might have inadvertently been offended.
Number one, you don't apologize for anyone who may have inadvertently been offended. That's not apologizing. That's kind of putting it on them. If you think you said something you shouldn't have said, you say what you've heard me say before. I'm sorry. I did not mean how that came out. I shouldn't have said it. Now that would have been the right thing for this counselor to say, to apologize for this.
We don't want any more black pastors coming in here, or other Jesse Jackson, whoever was in here earlier this week, sitting with the victim's family, trying to influence a jury in this case. And I'm not saying the state is even aware that Mr. Sharpton was in the courtroom. I certainly wasn't aware of it till last night. But I think the court can understand my concern.
Yeah. Your concern is that you don't want people there that project the outrage and the pain in this situation. You want to make sure that the people watching are as friendly to your client as possible. But the way you said it was offensive and projected a prejudice. Now keep in mind, the judge said he had no objection to the Reverend Al Sharpton, not Jesse Jackson. This guy really doesn't know the difference between these two men? Sharpton was there. Jesse Jackson wasn't there before, but now he's coming. So are around 100 other pastors. We don't have black and white pastors. You know, you don't say black police, white police, right? We got to get away from that. We don't want to play to it. If you watch this show, you likely know the level of lawyering practiced by Kevin Guff. You saw it when he came on and failed to explain what his client, William Roddy Bryan Jr., was doing recording Arbery's death in the first place. In fact, he embarrassed his own client. Listen to this. In the police report, the McMichaels referred to a Roddy. I'm assuming that was you, yes?
Okay.
Hey, hold on, Chris.
Mr. Bryant, how did you come to be in the car videotaping that day?
Okay, we're not going there.
You don't want to talk about that either. All right. We didn't play the part where he was like basically saying his client's too stupid to answer any of these questions for himself. So that's what you're dealing with. The reason this lawyer saying something about black pastors resonates is because it speaks to what this trial is all about. The fear of blackness for the defendants. Why else did they decide to chase this guy jogging through there? You don't think it had anything to do with the fact that he was black? Now look, it's not a bias-specific crime, but it doesn't have to be. And it's not just about what happens in the courtroom. I tell you all the time, we only know what we show.